Yes, Mr. Butler.
Thank you, my lord. We were in Masri.
Yes, tab 10.
Thank you. And we were at paragraph 26 of the judgment of, I think, paragraph 24 perhaps. Sorry. Can I just ask you to read paragraph 26 of the judgment of Lord Mance?
Yeah.
There is, we submit, I understand not to be disputed by the bank, no common law power to require the examination of an officer of corporate judgment debtor, no common law power to make an order requiring a person outside of the jurisdiction to attend court to be examined. And even when the court is made under this rule, under 71.2, that power is a limited power made against someone who's physically in the jurisdiction at the time is made. We say it would be wrong, therefore, for it to be said that inherent in the power under 71.2 to make an order against someone is a power to make an order that couldn't be made under that source power. That's the essential point that I made. And that's what the bank is effectively contending for, because it's effectively saying that because the court made order 1, which was a 71.2 order, it can now make order 2. Order 2 would require Mr. Vick to attend in person in this jurisdiction to be examined, to give information. That is an order that is premised upon 71.2, and we say it goes beyond its scope and can't be found to be one within it. It's using 71.2 as a platform to go further. We say that can't be the case. There's no inherent power to do it. There can't be an implied inherent power to do it. The issue in some of the issues in Masri were revisited by Lord Mance in the Singularis decision in the Privy Council. Could I turn to that next, please? It's in Authorities Bundle, tab 16. This decision was about the extent of the common law power. In fact, it was the common law power of the Court of Bermuda, but I don't think that makes any difference. The common law power to give assistance to foreign appointed liquidators. Those liquidators had come before it, and they were seeking relief against a PwC entity that was within the jurisdiction of the Court of Bermuda. And so PwC was itself within the in personam jurisdiction of the Bermuda Court. And the assistance that the liquidators were seeking were in the form of orders for provision of information. So it wasn't, save in one respect, which we'll see, about extraterritorial powers, but it does reinforce, as we will see in my submission, once again, that the court's inherent jurisdiction has its limits, and the specific concern about the court's power to order the provision of information. Lord Sumption identified the issues before the court at paragraph 8, page 403. Two issues. The first is whether the Bermuda court has a common law power to assist a foreign liquidation by ordering the production of documents in oral and documentary form in circumstances where, 1, the Bermuda court has no power to wind up an overseas company such as Singularis, and 2, its statutory power to order the production of information is limited to cases where the company has been wound up in Bermuda. The second issue is whether, if such a power exists, it is exercisable in circumstances where an equivalent order could not have been made by the court in which the foreign liquidation is proceeding. See, paragraph 9, he said that the common law of Bermuda is the same in every relevant respect as that of England, although he noted that in England the common law concerning cross-border insolvencies has developed. There's a discussion of the concept of modified universalism in the judgment. I don't think we need to be detained by that, because we can go straight to paragraph 19. 19F, so that's at page 411. And if we might just call for assistance, the principle of modified universalism it's about treating an insolvency as having a global effect, and the court's limited powers to provide assistance to that. And what was said is, in the board's opinion, the principle of modified universalism is part of the common law, but it's necessary to bear in mind first that it's subject to local law and local public policy, and secondly, that the court can only ever act within the limits of its own statutory and common law powers. What are those limits? In the absence of a relevant statutory power, they must depend on the common law, including any proper development of the common law. The question how far it is appropriate to develop the common law so as to recognise an equivalent power does not admit of a single universal answer. It depends on the nature of the power that the court is being asked to exercise. On this appeal, the board proposes to confine itself to the particular form of assistance which is sought in this case, namely an order for the production of information by an entity within the personal jurisdiction of the Bermuda court. The fate of that application depends on whether, there being no statutory power to order production, there is an inherent power at common law to do so. The fundamental question identified by the assumption is whether a power of compulsion of this kind requires a statutory basis. And he drew what he describes as an important distinction between evidence and information. Essentially, Lord Sumption concluded is that there is less of a problem with requiring the provision of information than the provision of evidence. You can see that in paragraphs 20 and 21. Or rather, it was information, this is 21, for the performance of the liquidator's ordinary duty of identifying and taking possession of assets of the company. He discusses in paragraph 93 the Norwich Pharmacal jurisdiction. And he said that illustrates the capacity of the common law to develop a power in the court to conduct the production of information when it's necessary to give effect to a recognised legal principle. He said an analogous power arises in the present case. Relief is not being sought by way of assistance to a litigant who can rely on ordinary forensic procedures for the purpose. And you can see at E, he says, having discussed the principle of modified universalism, which is founded on the public interest in the ability of foreign courts exercising insolvency jurisdiction in the place of the company's incorporation to conduct the winding up of its affairs on a worldwide basis. He said, this is a public interest which has no equivalent in cases where information may be sought for commercial purposes or for ordinary adversarial litigation. And you'll see at F, he says, the sentence begins, none of the reasons which account for the common law's inhibition about the compulsory provision of evidence have any bearing on the present question. Now, at 25, page 414, he said, in the board's opinion, there's a power at common law to assist a foreign court of insolvency jurisdiction by ordering the production of information in oral or documentary form, which is necessary for the administration of foreign winding up. In recognising the existence of such a power, the board would not wish to encourage the promiscuous creation of other common law powers to compel the production of information. The limits of this power are implicit in the reasons for recognising its existence. And he makes the point it's all to do here, essentially here to do with the insolvency jurisdiction. He notes it would not, for example, be available to assist a voluntary winding up, which is essentially a private arrangement. you'll see a few lines down at G, it says it follows that it is not available for purposes which are properly the subject of other schemes for the compulsory provision of information. Now, in fact, however, the application was dismissed because there was, you can see in paragraph 29, there was a further limitation which caused the liquidators formidable problems. What they were seeking in Bermuda wouldn't be obtainable under the law of the jurisdiction to which they've been appointed in the Cayman Islands. So they were going abroad to seek more than they could even get at home. So they needed to be, the powers, the common law power that Lord Sumption recognised was one that had to be not only available in the domestic jurisdiction, but also available in the foreign jurisdiction within this regime. So that's Lord Sumption. Lord Collins, paragraph 417, sorry, page 417, paragraph 32. He said that the appeal should be dismissed because the ground on which the joint liquidators based their appeal was unsupportable. Namely, that the court has had common law the ability to exercise powers which are analogous to statute powers, which would have been exercisable in the case of domestic insolvency, but which do not apply in the international context. So liquidators had said, if we've been appointed under the Bermuda insolvency legislation, we could do this. So the court should do it for us by analogy. And that wasn't the base on which Lord Sumption had thought it was potentially workable either. I don't think we need any more from Lord Collins. Lord Clark actually perhaps slightly wrong. There is one passage in Lord Collins I'd also like to show you at paragraph 69. This is under a subheading called judicial lawmaking. And at 69 he said, the approach which is articulated by Lord Sumption is itself an example of the development of the common law since, as Lord Mant's JSC's opinion clearly shows, it goes beyond what has previously been understood to be the power of the court to order information. Lord Clark gave a judgment which begins at paragraph 109, page 432. Lord Clark was of the view, and he agreed that the appeal should be dismissed for the reasons given by Lord Sumption. So that would be because of the limitations in the domestic jurisdiction, and that liquidators doing more than they could get at home, so to speak. And he added a short judgment addressing whether the Bermuda Court has a common law power to assist foreign liquidation by ordering the productions of information in oral documentary form, and then identifies the same issue which we've seen. And you see in paragraph 110, he agreed, so Lord Clark agreed with Lord Sumption. And at paragraph 112, he noted again it's based upon the principle of modified universalism. It's based on the public interest and the ability of foreign courts, essentially, to assist in orderly winding up affairs. He also agreed, this is the last lines, I also agree with Lord Sumption, paragraph 23.1, that this is a public interest which has no equivalent in cases where information may be sought for commercial purposes or for ordinary adversarial litigation. And at 113, I agree, he said, the board would not wish to encourage the promiscuous creation of other common law powers to compel the production of information, but that the limits of this power are implicit in the reasons for recognising existence. To essentially agree with Lord Sumption. We then have Lord Mance and Lord Neuberger. Lord Neuberger agrees with Lord Mance. Can I show you Lord Mance's page 434, paragraph 118? So the next page. So at 118, Lord Mance agreed with Lord Sumption on that the short answer to the second question is negative. So it was unnecessary to answer the first question, although Lord Sumption has devoted the major part of his opinion to this question. and Lord Mance expresses some views upon it. And you'll note at paragraph 123, page 436, Lord Mance noted that neither the court below addressed any observations to the questions whether any jurisdiction exists or, if it existed, could properly be exercised to make orders against and serve Paul Sotheby and other partners or officers of PwC outside the jurisdiction of the Bermuda court. So I think the orders had actually, in fact, involved orders directly against individuals, not just against PwC. Lord Mance found that problematic, and you'll see that 124. It is clear that the Chief Justice's order must, on any view, have gone well beyond any jurisdiction which exists at common law in relation to PwC's partners and officers outside the Bermudan jurisdiction, as opposed to PwC itself, which was within such jurisdiction. He then refers to his own examination, which had been agreed by the other members of the House of Lords in Masry, which we've seen. And at H on this page at the bottom, he also refers to Re Tucker, where Lord Justice Dillon, after noting the limitations of the powers to serve out of the jurisdiction to subpoena witnesses, said against his background he would not expect section 25(1) of the then Bankruptcy Act to have empowered the English court to haul before it persons who could not be served with necessary summons within jurisdiction of the English court. And you'll see at paragraph 135, 441, where I part company with Lord Sumption is his assertion that the hitherto limited principle of modified universalism, which I have just described, extends to or justifies or would be an empty formula without the assumption or exercise of a common law power to haul anyone before the court. To use Dillon LJ's word in ex parte Tucker, to be interrogated and to produce documentation of payment being in contempt, simply because it would be useful for the foreign liquidator to be able to do so and might enable him to locate some assets or better understand the company's affairs. There is a step leap between enforcing rights to identify assets and obliging third parties to assist with documentation and information in order to discover a company's assets, etc. And you'll see he addresses at G the concept of a recognised legal principle, which was referred to by Lord Sumption in relation to Norwich Pharmacal Relief. And he said that begs the question whether the principle of modified universalism extends beyond the protection of identifiable assets within the jurisdiction to enable rules to be made compelling third parties to assist with the provision of information and documentation which may assist the tracing of such assets or otherwise assist the insolvency practitioners in their understanding of the company's affairs. Then he makes the point in 136, information is a precious commodity, but is not one which is generally capable of being extracted in court from private individuals without special reason. And the potentially intrusive, vexatious and costly nature of the exercise of any power to do so is apparent from the form of the Chief Justice's order in this case. The common law has not hitherto accepted any such jurisdiction. And he addresses from B to D concerns that even the suggestion by Lord Sumption that this shouldn't be taken as encouraging a promiscuous new jurisdictions was itself problematic. He said, in the last 4 lines, although I disagree with it, such attempts may well be difficult to resist. Although I disagree with it, such attempts can only be encouraged by the statements at the end of paragraph 21 from Lord Sumption's opinion.
I'm not quite sure where this is all going, because what we got is a disagreement in principle between Lord Mance and Lord Sumption about whether this power exists. The majority think it does, didn't apply in the particular case, all to do with insolvency, and Masry specifically says, well, you can't draw an analogy with insolvency. So why are you citing this case? What is the proposition you wish to derive from it?
Thank you, my lady. I'm citing this to support the proposition that the common law doesn't simply and easily recognise a power to require somebody to provide information. That is consistent throughout all of the judgments. Because even in Lord Sumption's judgment, which was agreed with by Lord
Was it?
Collins, Lord Collins, he was very careful to say it arose against a particular background of insolvency, which, as my lady has noted, Masri also drew a distinction with insolvency. And so what I say and what we submit is that reinforces precisely our point that there is no inherent common law power to order the provision of information.
I think that's common cause, isn't it?
And there cannot be, in our submission, consequential upon that, and there shouldn't be some simply very loose assumption that because an order has been made under 71.2 requiring information on a particular time, that this then gives the court power to make orders, further orders, the effect of which is to require somebody out of the jurisdiction to provide further information.
But we're dealing with a statutory power in
Yes.
71.2, and,
Yes.
and 137 shows that Lord Mance defines very narrowly the common law powers to require information, and the statutory power we're concerned with clearly goes wider than that.
Well, the statutory power we're concerned with doesn't go so wide as my learned friend's
No,
order.
but it goes wider than the common law powers that are being considered in this case.
Yes, but it is only the statutory power that is the source and that is what confines the jurisdiction.
No, I understand your argument.
So-
I'm just perhaps echoing my lady's point, but I'm not sure how much we get out of this. Focusing as it does on common law powers when it's common ground that we're dealing with a statutory power that by reference to initial grant does go further than common law powers.
Well, when we say it's a statutory power, of course, this is said to be implied out of the statutory power.
No, 71.2 is a statutory power
Yes.
because it's a provision in the rules.
Yes, but the order which my learned friend is seeking is said to be implied out of the
Yes,
statutory
it's said
power.
to be incidental to that.
Yes,
power.
quite.
Yeah.
And so we do have to consider whether or not it makes sense to say that the implied statutory power goes broader than the common law and goes broader than the actual source power, the statutory power. And we say it does both. And so the order which is being sought by the bank, we submit leads to radical step changes in terms of the established scope of the court's power. It would involve making an order anew, requiring a non-party to proceedings to provide information outside the scope of Part 71. And I say non-party proceedings because it's all about information, as my learned friend makes clear, to enforce the judgment against Sebastian Holdings. And it's making an order against someone who's outside the jurisdiction so as to make them come to the jurisdiction to do that. We say that that is something that cannot fairly or properly be found as being inherent or intended to be inherent within CPR Rule 71.2. Yeah, that's my point. And we also say that that also feeds to the point about, what you might call
71.2 does. It can properly require someone who's outside the jurisdiction to come to the jurisdiction. That's what happens if you serve someone fortuitously if they're here and then they go back to where they were from. But
well, that order doesn't.
you make the order and they've got to come here to give the evidence.
Well, the order can only be made if they're in the jurisdiction. They have to actually physically be in the jurisdiction when you serve them with the order.
Yes.
So necessarily, the order can't be made to make them come.
No,
Once they've
because
got-
the order requires them to come on a later date,
yeah, the order
and
imposes,
they may well not be here on a later date. So you are then requiring them to come
that
from
then-
abroad to attend the examination.
well, that though involves them breaching an order made when they were here. So in my submission, that doesn't require them to come because the order, when made, isn't saying you must come. It says you must attend the court.
It says you must attend court whether you've gone outside the jurisdiction or
Yes.
not. That's what it's saying.
Yes.
So the fact that they're outside the jurisdiction, it's not the same thing as making an order which is served on them outside the jurisdiction, requiring them to come into it. That's the distinction.
Yes, and what we say is that that distinction holds good here because the order that's now being sought here isn't being made against Mr. Vick when he's here, that says, Mr. Vick, you must attend court. But it's actually an order to be made against Mr. Vick saying, Mr. Vick, you must now come here.
Well, it all boils down, doesn't it, really, to exactly the same point that we've been debating, which is whether or not it's a continuation or a variation or some kind of modification of the original order, or whether it's a brand new order. You say it's a brand new order and you can't make one, and they say it isn't. That's really what it boils down to.
There is some sense in that, my lady, if I may say so.
But, you know,
But
I do believe in grasping the nettle from time to time.
which I hope I've been endeavouring to do. That's what I've been trying to do, at least. Subject matter jurisdiction also, my lady. So what the just and convenient element, discretion, however one wants to put it. That is relevant here. We are 11 years on from the order. The order was obtained. There was the hearing. At the end of that hearing, no further questions, no adjournment, then contempt proceedings, all the way through. The bank let the order slip through its grasp, if you might put it that way. It slipped from its grasp. It now, because, and we're only in this situation again, I'm going to remind my lady as I began, my lords, when I began, because of that particularly extraordinary set of circumstances. And Mr. Vick is not responsible for the expiry of the order. To now make an order all this time later to require him, who is a person out of the jurisdiction, to now come and do something further afresh, my submission, is one that the court shouldn't make. It is not, and I recall you, I'll remind you what my learned friend says the purpose is, to provide information. It's a very intrusive remedy.
Well, that's to provide information he should have provided before and hadn't.
Well, we part company on that because clearly they want information that he couldn't have provided before because they want to ask him as to what the position is today. And that feeds my further point because again, it's a broader order. It's a more imposing order. It's come and now be asked over however many years worth. So my submission, that is why at the second stage, so when I say how many years, because they now want to ask from 2000, presumably they want to test everything from 2015 up to 2026 or whenever the order would effectively be made, or the hearing would be, I should say. So in my submission, it isn't appropriate that that order should be made, even if it could properly be made. I ought to briefly try and address, we'll come back to Lord Nugee, or Justice Nugee's question about documents and the approach and the order of different documents. Can I just show you one thing? It's in, I hope you have part 71. It's rule 71.2 itself. The scheme of the code. Yeah. 71.2(1), a judgment creditor may apply for an order requiring a judgment debtor or if a judgment debtor is a company or other corporation officer of that body to attend court to provide information about 1, the judgment debtor's means, or any other matter about which information is needed to enforce a judgment or order. Such an application, an application under paragraph 1 may be made without notice, must be issued in court or county court, etc. And you'll see in 3, it must be in the form and contain the information required by Practice Direction 71. At 4, it can be dealt with by a court officer without a hearing. And then 5, if the application notice complies with paragraph 3, an order to attend court will be issued in the terms of paragraph 6. So paragraph 6, a person served with an order issued under this rule must attend court at the time and place specified in the order, and when he does so, produce at court documents in his control which are described in the order, and answer on oath such questions as the court may require. So that's actually an obligation to produce documents at court. Now, if we then look at the order in this case, we know, it required the documents to be produced, I think, 14 days in advance of the hearing. It's supplementary bundle, tab 16, page 136.
Are you saying that there was no power to make that order?
I'm not going to. I'm not going to raise that issue. I'm not getting into that issue, if I may. But I say that there is a limit. There is a limiting power in the rule itself. Effectively, a long stop.
Would you say actually the proper course is to, which is empowered by the rule itself, is to require him to come to actually produce the documents and then adjourn so everybody can have a look at them, and then require him to come back to be questioned about?
That appears to be how the rule is intended to work. Yes. Now, if the order has, as here, has provided for the documents to be provided in advance, 14 days, I would accept that you could vary the order to say actually do it 7 days in advance. But once you get to the hearing, which is the long stop date, the date at which you must attend a court to produce the documents, after that deadline has passed without any adjournment, you can't then seek, again, just as with extending the hearing after the event, or seek a further order just on the back of the original one, because that is making a new order which goes beyond the scope of the rule.
So that, so far as powers are concerned, no difference between documents and answering questions. They can both only happen at the time that's identified for attendance.
Yes.
Or an adjourned hearing if there is an express adjournment.
Right.
That's the submission?
That's my submission. And it all works then in my submission if it gets adjourned. Then it keeps alive the duties, the powers. But what is different, as I've said a number of times now, is once it's ended, then you need a new order. I was going to propose to move on to ground 2 then. I'll do that, which is the challenge to discretion. I think I can deal with that hopefully rather more shortly. In our submission, there's no proper basis identified to interfere with the judge's decision, which was a multifactorial evaluation and exercise of discretion. And this court knows, and we've cited Tan Fern and Cameron MacDonald, Authorities Bundle, tab 5, page 91, paragraph 32. The appellate court should only interfere when they consider the judge of first instance has not merely preferred an imperfect solution, which is different from an alternative imperfect solution which the Court of Appeal might or would have adopted, but has exceeded the generous ambit within which a reasonable disagreement is possible. We say the judge carefully weighed up the issues and formed a decision on discretion. My learned friend identified what she said already yesterday were 4 reasons why she said the judge's decision should be interfered with. Reason 1, it said, was that making the order in and of itself enforces the court's orders, upholds its authority, and protects the integrity of its purposes. Now, if it is there being said the judge was wrong because she was required as a matter of principle to make this order, so she had no discretion, in my submission that's hopeless. Of course the court, when it's considering whether to make an order, has to consider whether to make it. And in fact we saw, and I think my lady referred to it yesterday, how we even saw that in Wilkinson and Amgen, when the court is considered whether or not to make an order. So as a matter of principle, it's absolutely right that there's a discretion. So in my submission, that argument, so far as it appears to be suggesting that the judge had no discretion, is simply wrong. And of course, if we need to go further, the judge was well aware of the history. She gave a detailed exposition of it. She did it in a way which wasn't flattering to my client. And at paragraph 131 of her judgment...
131, did you say?
131, my lord. She said in second sentence, despite the instinctive unwillingness to allow Mr. Vick to continue to evade his responsibilities, I would conclude that any such order would almost inevitably be an empty gesture. So the judge had full in mind the consequences of the order she was making. So there's nothing in that reason one, a submission that justifies interference.
If she was wrong and it isn't an empty gesture.
That's a different
Yes.
point, which I will come on to. I'm going to go through each one of my learned friends. So reason one, nothing to it in my submission. Reason two, my learned friend said, effectively other judges considered that a further examination might be a worthwhile exercise. This perhaps bleeds into my lady's point, but I'll deal with it on its own terms before I get to my lady's point. If the submission is being made that this judge's decision should be interfered with because when she made a decision on the application before her, she should have effectively outsourced her decision making to other judges, in my submission that's totally wrong. The judge made a decision on the information and evidence before her. So this is not an independent reason either. Reason three, it was said, the judge should have proceeded on the basis that Mr. Vick is, and I'm quoting here, more likely than not to attend a further examination. So that, although it's described as a challenge in law on learned friends grounds, is a challenge to the judge's evaluation of fact. The judge gave detailed consideration to why she made the decision that she made. And as I said, and I've developed, there is no proper basis to interfere with it. The judge, at paragraph 136, expressly identified the purpose of an order to give a judgment creditor a means of obtaining information for the purposes of enabling enforcement of the judgment debt against SHI. Let me just note that the way it was put by my learned friend was the judge should have proceeded on the basis that Mr. Vick was more likely not to attend a further examination. It wasn't submitted, more likely not that he would provide the information that they say that he's required. And the judge's decision is more nuanced, because what the judge said is there are a number of reasons which together suggest strongly that even given the inference that Mr. Vick has relevant information, making such an order would not achieve this purpose or even materially assist in achieving it. And the purpose is provision of information to enforce the judgment. And can I just whilst we're here, because I can then just briefly knock off what appears to be reason four. Reason four was the judge's approach was wrong because it was said that the evidence shows Mr. Vick continues to be able to give instructions and directions in respect of SHI and has an ongoing involvement in its affairs. The judge specifically has addressed that in 134 and 135, and in 136, she specifically recognised that. But her point is that where there's going to be further information in terms of matter of likelihood. So this fourth reason, again, not actually a reason that could justify interference. So just to recall, and you'll read, I don't propose to read them out again, or read them at all, paragraphs 137, 138, 139, 140, 141, where the judge set out her reasoning for forming the view that she did. Just in terms of the high level points, Mr. Vick was examined in December 2015. The contempt proceedings were brought on the basis that it was said that the proceedings were designed to encourage him to provide information. He was, in the context of those, cross-examined for 4 days in relation to the answers he'd given at the single-day examination. That was to establish that he had not told the truth. It was a detailed and granular exploration of his answers. He was held to have lied at the examination and at the cross-examination in the context of contempt. And at the consequentials hearing before Mrs. Justice Mulder, it was submitted by the bank that obtaining a suspended order was something that shouldn't happen because it was going to involve going round and round in circles. There was quite a lot said about that by the bank. The transcript of the sentencing hearing was before Mrs. Justice Cockrell. We only, I think, have a small part of it before the court today. What we do have is an extract from the transcript before Mrs. Justice Cockrell, where I read from the transcript before Mrs. Justice Mulder. So I can just show you, if I may, just a couple of paragraphs of that. Given that nobody said at the time that I was making up what was in the transcript from Mrs. Justice Mulder hearing, I suspect it's not going to be challenged as being inaccurate. I hope it won't be. It's in the supplemental bundle at page 127. If I can ask you to read page 127. So it's tab. I think it's tab 15, apologies. Yes, it is tab 15. If I can ask you to read from line 7 on this page.
So who is this?
In this, this is me reading to Mrs. Justice Cockerell what Miss Delaney had said at the sentencing hearing. If you could read over the page.
That was the bank's submission. Your submission was not. Mrs. Justice Mulder suggested that she was persuaded by Mr. Vick that he intended to comply. There was evidence before her to that effect. So does this boil down to a submission that Mrs. Justice Mulder shouldn't have accepted your client's evidence at face value?
No, my lady, no, not at all. It goes to two things. It goes to the judge's decision that there was an error of futility about this, which she'd reached independently from looking at the history, and then by also seeing what the bank had itself had said, which reinforced that view. So my submission, no, I'm not suggesting that. But it also goes to our respondent's notice point about proper purpose, because the bank's own position, and I don't know if you've finished reading because it continues over the page, is that having an examination of Mr. Vick is a futile and pointless exercise. That's what they said as to why they said there should be no suspension. There was a suspension on terms of further examination. That further examination didn't happen. In our submission, it clearly didn't suddenly become the bank's view that Mr. Vick, who hadn't attended to be examined after the lapsing of the contempt order, was suddenly having a sea change in his approach. And that's actually clear because the bank was saying in their evidence, and you've seen reference to it in Mrs. Justice Cockerell's judgment, the bank's saying that Mr. Vick continues to be involved in SHI and is not telling us everything that's going on. So my submission, that goes to the improper purpose. The purpose is to gather information to enforce the judgment. The bank didn't say itself, that it's going to get information from Mr. Vick to assist it in doing so. Its own position is it won't. But the judge separately decided on the evidence before her, my submission entirely impossible of being challenged on the grounds that my learned friend has put forward, that given the history, it was unlikely that material evidence was going to come through, and that overall, given the amount of time that had been spent, it was appropriate not to make the order. My learned friend's only challenge is resolved to the suggestion that she should have proceeded on the basis that Mr. Vick is more likely than not to attend a further examination. My submission doesn't come close to justifying interfering with the judge's order.
But you put it in terms of her finding was unlikely. Is that enough? I entirely understand your submission that making orders that protect the integrity of the court is not a knockout blow, but it is a relevant factor, and it may be said it's a particularly important factor, which, if it's to be outweighed by futility, needs something which comes quite close to certainty that it'll be futile, not there's just a risk that he won't give the information. And in terms of how the judge balanced those, all she said at paragraph 131 about the importance of the court's orders being upheld is, despite the unwillingness to allow Mr. Vick to continue to evade his responsibilities, which is a pretty mild way of addressing the point. When it comes to whether it's futile, you put it a moment ago that he's unlikely to, but I think probably the high watermark of her reasoning is at 140. Nor would any Part 71 questioning itself incentivize Mr. Vick by putting him in peril of imprisonment. I'm not quite sure on what basis she says that, given that he was anxious to turn up on the committal application and resist a finding of having failed to comply with the order. And then she goes on, even if committal were to result, the 2022 committal where Mr. Vick lied again demonstrates that Mr. Vick does not seem to be more than slightly incentivised by that peril. Now, if one looks at the whole history, and if an order were made and he was at risk of a further prison sentence, he didn't turn up, is there a justification for saying, given what's happened, he wouldn't be more than slightly incentivised by that peril? And even if it is that enough to outweigh the importance of the court's integrity being preserved by not saying, if we make an order, it may not be complied with?
So my submission, unpacking that a little bit, the judge clearly had in mind the consequences of the order that she was being asked to make and the implications for it. And my submission, the judge wasn't in paragraph 131 treating the order she was being asked not to make as being having no real grave consequences, in the sense of not recognising the importance of, or not appreciating the importance of what was said to be the public policy of giving effect to orders that had been made. And what the judge concluded in paragraph 142, it follows in terms of direct result, there is nothing to suggest that a further Part 71 hearing will advance matters. Deutsche Bank has tried these remedies before. They have not worked. There is no evidence to suggest a second round will be more efficacious. At the same time, this is part of the further evaluation, the process is burdensome to Deutsche Bank and the court. And she made quite, if we want to talk about case management, she made a number of points there.
Well, can I just focus on that they have not worked?
Yes.
They brought contempt proceedings.
Yes.
He attended and gave evidence in order to avoid a contempt, a committal. When the committal order was made, he argued strenuously that he wanted to comply, and therefore he should have a suspended order so that he had the opportunity to comply. Right up until the last moment, and indeed beyond the last moment, he argued that he intended to comply. He then had the good fortune, from his point of view, that Deutsche Bank dropped the ball, if I might put it that way, and the time had passed. What is there in that history that suggests that if he's exposed to a further risk of committal and going to prison, he won't seek to avoid that by answering the questions?
Well, what the judge held is when he was examined the first time, firstly, he was held to have lied before Mr. Justice Cook in the underlying trial. It's the non-party cost order and so on.
Yes.
Secondly, when he was examined under Part 71 on pain of the risk of committal,
Yes.
he was held to have lied.
Yes. Well,
Thirdly,
that shows an anxiety not to be sent to prison, doesn't it?
No, but the judge's point, it doesn't show a likelihood that he's going to provide the information which is the purpose of the order.
Well,
So he lied, the judge held that he lied in the Part 71 hearing when he was being asked to provide the information. At the contempt hearing, he was cross-examined about the information he failed to give, and Mrs. Justice Mulder held that he lied there. He lied before Mrs. Justice Mulder, it was held, about what he'd said, about what he meant, what he knew. So again, even though that was a contempt hearing where the risk is an order for imprisonment, it was held that he lied. So again, that is what the judge held shows on her analysis the unlikelihood that if he's asked questions another time that he's going to provide the information that, as she points out, hasn't been provided previously.
Well, let's look at it in a slightly different way. He managed to get out of being sent to jail, putting it bluntly, by promising to be a good boy and tell the truth next time. Now, it just happened to inure to his benefit that he didn't get that opportunity to tell the truth because, as you say, Deutsche Bank dropped the ball.
I think that was my expression.
Yes, but well, sorry, as my lord put it, dropped the ball. So we've never had a situation in which he's come back and had the opportunity he pleaded for on the last occasion, knowing that if he does it again, he's going straight inside because he's not going to get another suspended committal order. That's the incentive to tell the truth, surely.
My lady, but that would have been the same incentive at the other two occasions. Because if he turned up, if there was another Part 71 hearing and he attended, as Mrs. Justice Cockrell pointed out, if it was said that he'd lied again, there'd have to be a new contempt process. So we'd have to go through it all again. And so it's the same situation that was there before. And as the judge said,
Except
there's no
that
reason
it's
to...
much more likely that next time he wouldn't get a free pass out of jail.
I'm not sure my client would...
Sorry, I put it in the vernacular, but you know what I mean.
Yes, but in my submission, that underlines the problem with it. The problem here, one of the problems here, is that the court is having to look at the judge's decision,
Yeah.
and the judge's decision was a well-reasoned, proper decision. And what the court is saying is, well, maybe we could reach a different decision. That, I'm afraid, my submission isn't, of course, the test.
No, but I think what the reason I'm raising these as with you is the considerations we're talking about are really wrapped up in paragraph 140, which is the nub of her reasoning on this. And I'm questioning whether that's really a finding which is open to her in relation to the history of this matter.
Well, my submission, I wouldn't say that to extract that and say that's the nut, because there's a whole number of paragraphs where the judge has analysed it. As I said, the judge's ultimate conclusion is paragraph 142.
Well, if she's wrong about 140, that does undermine the whole of the other aspects of it, doesn't it? If Part 71 questioning would incentivise him to provide the information because of the peril of imprisonment, then she can't. That can't support then the finding which introduces everything at 131, that it would almost inevitably be an empty gesture, or that it would be futile.
But my lord, one can't take that out of context. It's after the judge has described the prior history and the judge's view, where she says that in 137, the obvious fact he's resisted providing information with a degree of determination for a decade. And the court have had ample evidence of his willingness to lie in order to achieve that aim.
Yes.
So when the judge is saying in 140 that she doesn't see it as likely that he's suddenly going to be incentivised to give the information, that is precisely because he wasn't incentivised the first two times. That's the point, and that's in my submission incapable of being.
But that's what I mean. The counter argument would be, well, if people lie about these matters, it's in the hope that they'll get away with it. And at the first hearing, he tells lies, and he hopes that there won't be any consequences. He's then faced with some consequences, which is he's accused of lying first time round, so he lies again in order to avoid those consequences. That doesn't work. Mrs. Justice Mulder then says, I've now got to sentence you. So he seeks to persuade her that he's changed his mind, and he will now provide the information. As it happens, he hasn't had to. The judge, Mrs. Justice Cockrell, may have taken the view that he was never going to comply with that anyway. That's a hypothetical question. He sought to do it by video link and then latched on to the point that the time had expired. But does it logically follow from that if a further order is made and he's asked some questions and he lies about them, and then he's faced with a further contempt and he's found to be in contempt, that he won't provide the information? I'm just not sure it follows. He's got away with the lying so far, but if the further order is made, yes, it's possible that he will lie again at the resumed hearing, but that's not the end of the road. So it isn't only a question of whether he will lie on that occasion. It's a question of whether the information which the judge accepted he had would ultimately be provided against the ultimate sanction of further committal. Isn't that the important question? But from a futility point of view.
So first point, Michael, whether or not Mr. Vick, the judge's view is whether or not Mr. Vick would tell and provide information, my submission isn't a question of logic, it's a question of evaluation of the evidence. And the judge's view, based upon all the past, was he wouldn't do it because he hadn't done it before, and there's no reason why she didn't detect any sea change to make her think that he was going to do it. That's the first point. The second point is the judge also did address the point that even if committal were to result, the 2022 committal where he lied again, she says, demonstrates that Mr. Vick does not seem to be more than slightly incentivised by that peril. And she also said, 142, is having said that Deutsche Bank has tried these remedies before and they haven't worked, she also addressed there that not only will an examination of Mr. Vick inevitably involve a multi-day hearing, that were a further committal application possible, that would add a further layer of time and costs, and history suggests it would do little more. So the judge did specifically consider that possibility. Can I just address one point? I think it was said that one of the things that happened is after the committal order, there was some provision of information by Mr. Vick, in terms of, and there was a question, but it's not being pursued because there was no activation application by the bank as to whether or not that information had been provided properly, whether he'd done the searches he was supposed to do, whether he provided accurate information. Can I just show you the evidence that was filed by the bank in support of this application? It's in Mr. Robinson's 10th affidavit. Sorry, 10th witness statement, I will say. It's in the supplemental bundle at tab 9. And we can go straight to paragraph 70 at page 71. Where the bank set out why it was seeking this order. So in paragraph 70, given the further examination has not taken place, it is apparent that Mr. Vick has still not remedied the breaches of the Part 71 order. Accordingly, he's not complied with his obligations, etc. And it's therefore appropriate for Mr. Vick to be required to attend for questioning about the financial affairs of SHI in order to provide information that he should already have provided under the Part 71 order. In addition, it is necessary for him now to be examined upon the further information and documents produced by Mr. Vick pursuant to the committal order and the contents of his witness evidence regarding the process by which he obtained and produced them. Now, that was, in our submission, clearly to go beyond just find, as is apparent even from their own formulation, going beyond providing information in relation to the Part 71 order. It was intending to examine Mr. Vick to establish whether or not he had complied with the conditions of the lapsed contempt order.
Well, that's consistent with the rather broad way in which the bank formulated its order the first time round.
It goes to the question of purpose. It's a question of the purpose for the application. The bank doesn't, as it said repeatedly to the court, think that it's going to get anything. The bank made clear in its own application that it was seeking to do something more than just get information. This application, our submission, and that's our respondent's point, hasn't been brought for the proper purpose or the genuine purpose of seeking to obtain information from Mr. Vick for the purpose of enforcing the judgment obtained against SHI. It's because the bank wants to try and put Mr. Vick under pain of contempt and try and went with no real belief that they're going to get any information from him.
Well, the pain of contempt won't do for you. I think it can only be abusive if the pain of contempt is not a factor at all. In other words, if it's not a factor that the risk of going to prison will produce the information. I think your case on abuse has to be that the sole purpose is penal. They never think they're going to get any information out of it, but they're determined to see him to go to prison for it because they've got this far and he needs to be punished.
Actually,
That's
in my submission, it'd be sufficient to say the purpose is not to obtain information.
well, exactly. But if a purpose, if it is a purpose to obtain information, as well as to punish, then is that an abuse?
If there were a legitimate purpose mixed with an illegitimate purpose, I think on the current state of authorities that wouldn't necessarily render it abusive, although it's
that is the dual purpose of contempt in any event. It's recognised to have a penal element, but
what we're focusing is the purpose of this application.
yes,
And we say that it is not the purpose of this application to gather information
at all.
at all.
Yeah.
They
And
don't
that's why I put
yes,
it to you.
yes,
that
quite.
Pain of imprisonment won't do. I think your case on abuse has to be the sole purpose is imprisonment, not and getting information is not any part of the purpose.
Yes. Very briefly, because I need to let Mr. Hamilton say far more interesting things to you. One last thing to show you, two last documents, if I may. It's the correspondence in this bundle, which you're in the supplemental bundle, tab 10 and tab 11. This is a letter from Breacher sent on the 14th of November, so before the hearing that took place before Mrs. Justice Cockerell, saying that we thought the application was variously flawed. And in paragraph 3, notwithstanding and without prejudice to what is said above, in the interest of avoiding unnecessary waste of court time and costs, Mr. Vick is prepared to agree to meet voluntarily with your client via video link to answer questions concerning SHI's financial means of the kind that a creditor would be able to ask of a director of a judgment debtor attending for examination pursuant to Part 71 order, in return for the new application being withdrawn with no orders to costs. Time and date of the meeting can be agreed once your client has confirmed that it's agreeable to this proposal. So there was an offer there to give information.
Yes.
And the bank's response, which the next tab is, and you'll see in paragraph 3, your client is a serial liar and a fraudster, determined to prevent Deutsche Bank from enforcing SHI's judgment debt against SHI's assets. Just pausing there. That, of course, is consistent with what the bank has been said at the sentencing hearing. The Court of Appeals held here as a man will do what is necessary to prevent Deutsche Bank from paying its judgment debt. Cook J has held that the whole history of the proceedings against SHI and Mr. Vick's creature company reveals attempts by Mr. Vick and Mr. Johansson to avoid liability, to deceive the court, conceal the true state of SHI's financial affairs. Your client could at any time, well, I'll ask you to read B and C.
Well, it's C, isn't it?
Yes, it's C, but I'm not sure how this helps you, does it? If we're looking at futility, your client is saying through Breacher, I have got the information and I'll supply it to you, which doesn't sit very happily with your futility argument. And Freshfields are saying, yes, but that's given the history, the idea that he's going to do that voluntarily is unlikely, and that's why it needs to be have a penalty attached to giving false evidence, not we don't want the information or it's fanciful he would give it, but that he'll only give it under pain of risk of contempt. Now, how does that help you?
So on futility, so the judge's finding that this was futile, which was the judge's finding, the judge's conclusion was, in light of all the evidence, she didn't think Mr. Vick would give any relevant information. This doesn't go to that point.
No.
My submission. On the abuse question, whether it was bought for a proper purpose,
Yeah.
as we say, the bank made clear before Mrs. Justice Mulder, this is all going to be futile. It was given the opportunity to, and it's a futile even if you make, if you don't give it.
I've got all that one. I'm not
Yes.
sure what you get out of.
So what we get out of this
these
is
letters?
a voluntary opportunity to provide information. They say, no, your client can repeat. I have your point about C, but you see what they said in A and B about my client, all of which feeds the point that they don't actually believe that he's going to provide information.
Thank you.
Unless I can assist you further, I'll pass you on to Mr. Hamilton for ground 3. Can I just note one thing in case we don't have time to come back to it? At the very end of my learned friend submission yesterday, she said that they had some thoughts about what might happen if they win on grounds 1 and 2, but lost on service, about what should happen next. I would probably have quite a lot to say about that. I'm not sure I'm going to have time to do that. It may be that it's more appropriate that, because I'm envisaging that judgment may be reserved. I don't know if that's
That's a safe bet.
Safe assumption.
it's a dangerous assumption. So on that basis, perhaps we can park that because
Well, I didn't understand Mr. Laney to be making any submissions on that topic, which were addressed to any order that we might make about it. And I know, for example, that the oral application for service by an alternative method, although it might look as though it was dismissed, was dealt with in the order as something that hadn't been ruled on and therefore isn't part of ground 3. And if we were in favour of allowing the appeal on grounds 1 and 2 but dismissing ground 3, then as we understand it, there'd be an opportunity to either seek to serve under the Hague Convention or make an application again in what Mrs. Justice Cockrell regarded as a proper manner. And I didn't understand Mr. Laney to be saying that any other options were matters on which we were being asked to express a view, and that those would all be matters which, if that were the outcome, would have to be addressed at first instance, if at all.
So yes, so
Okay.
just
Have I understood that correctly, Mr. Laney?
You have, my lord, exactly.
so just to put down the marker, of course. So I made the point earlier. The hearing for Mrs. Justice Cockrell was not a dress rehearsal; it was the hearing. We'd have something to say about the idea that having had a hearing of an application which they hadn't served, that they could then seek to serve it, so as to then have a further application hearing at a later date on it. That's I just put that marker down. And there might be a moment to have that, depending on where, of course, the court comes to. And just the second point, which perhaps has now fallen away, is that part of the confusion was the bank's grounds of appeal, in terms of the orders they were seeking to set aside, sought to set aside the paragraph in the order of Mrs. Justice Cockrell, where she said, "I make no order upon the alternative service application." But then in the next box, they didn't say that they were seeking any other order. So
Ground 3 was firmly and clearly directed to the basis on which it was argued by reference to the 2017.
right. So I just wanted to put those markers down for what it's worth, so there can be no misunderstanding of that we may have things to say depending upon where things go, but it's too early to say.
Can I, just before you sit down, the ancillary relief or dispute about whether there was proper service on Brecker. Is it Brecker or Brecher?
I think it's breacher.
Breacher. Proper service on Breacher of the permission to appeal documents. Do you want to say anything on the point that you made an application to strike out, you made an application for a declaration of non-service, the application in relation to non-service was successful and you got the declaration, the application to strike out was effectively successful because their application was dismissed, and that for those purposes, Breacher expressly gave their address as the address for service in relation to those applications, and that must carry with it an address for service for the purposes of an appeal from those determinations.
The short answer is no. I wasn't proposing to say anything about it. If I may turn my back for a moment.
Yeah.
Mr. Hamilton may have a word or two to say about
Okay,
it,
all right.
but I've detained you long enough. Thank you very much.
Thank you. Yes, Mr. Howard.
Sorry,
sorry,
Mr.
Mr.
Hamilton starts. I apologise to interrupt. We were sent a number of new documents that I understand Mr. Vick may wish to seek permission to rely on. If he does move that application, I have the pleasure of dealing.
My lord, perhaps I can deal with that issue at the beginning of my submissions, if that's convenient. I was going
Yes.
to ask your lordships whether you prefer to deal with that at the outset.
We
or
don't
when
know
I
because we
come
don't know
to
what
the-
these documents are. But
Beg your pardon, my lord?
we don't know because we don't know what these documents are.
Well,
but
yeah,
but address us in whatever order you think is most convenient.
Perhaps, my lord, if I address first the point that you raised, my learned friend, about the point taken by the bank in relation to whether Mr. Vick has essentially now given an address for service by virtue of having made the cross application in front of Mr. Justice Cockerell. And in relation to that, I would submit that it doesn't work to say that where a party applies for a declaration that they haven't been served, and that the other side were not entitled to serve them in the manner that they did or at the address that they did, one can't then piggyback off that application, that successful application, say, well, now you have given an address for service and we can serve you at that address.
No, this is service. This is only service of the appeal documents.
Yes, my lord.
Just that narrow point.
Yes, my lord. But
So assume that we dismiss the appeal on grounds 1, 2, and 3. The question arises: well, is there an additional point in any event that there was not good service of the permission to appeal documents?
well,
So it's a narrow point.
well, yes, my lord, there is. And we've got the documents on that. And Mr. Vick took the position that he had not been validly served with the appeal documents. My learned friends have made an application for a declaration that he has been validly served.
Yes.
And one of the arguments they rely upon is that he has given an address for service by making the cross application. But
Yes.
my submission, that doesn't work because by giving, there's a question whether when a party disputes service, they thereby give an address at which they can be served. And certainly if a further application being made below, that wouldn't work.
It's not suggested that they thereby gave an address for service by which they could properly have been served in relation to the application with which we're concerned. It's a question of whether they were giving an address for service at which they could be served in relation to any appeal documents appealing from the application made by them in which they had given that address for service.
Well, my position on that would be that no, that doesn't work.
Well, why doesn't it work? Because if you come to the court and say we weren't properly served and there's a dispute about that, then the losing party has a right to appeal that, subject to permission. Surely, by putting the whole of that dispute before the court, you are also inherently consenting to any appeal being put before the court. Otherwise, it's a nonsense.
Oh, my lady, I mean, the alternative would be that Mr. Vick didn't attend the hearing and then relied at a later stage on his not having been validly served. And that would simply cause delay. So it rather puts a party at a disadvantage. If that application had then been refused by Mr. Justice Cockerell without Mr. Vick attending, then the bank would still need to appeal, and they would need to get permission. Well, they wouldn't need to get permission. They would need to serve Mr. Vick by the proper means.
If you look at your application notice, which is supplementary appendix tab 3, page 14, box 4 says, address to which documents about this claim should be sent, and there is breacher's address. And the note says, if you're not already a party to the proceedings, you must provide an address for service of documents. Now, that's only documents about this application, but why does that not include an appeal from the order made on that application?
I think that the entire way through, my lord, we've been proceeding on the basis that proceedings are without prejudice to Mr. Vick's position that he could not be served, both below and in this court, that he could not be served at breacher's address.
But take it in stages as well. But before you get to any appeal, any documents that related to this application, could they be properly served by being sent to breacher? That seems to be what this document says.
Suppose
So
there was a
before the
witness.
judge.
Suppose there was a witness statement in response to the witness statement that supported this application. Could that be served at breacher's address?
Well, my lord, we would say no, because
So you can bring an application in which your documents can be put before the court, but nobody else can put any documents to you.
well,
That seems a very bizarre way of proceeding. You may be right that Mr. Vick could have simply taken no part and subsequently said, but nothing has ever happened that affects me. But when he, through breaches, has made a cross application, it seems bizarre to say, but nobody can send me any documents in relation to it.
yes, my lord, but I mean, how that works in the context of, and essentially this is equivalent to, in my submission, a Part 11 application. Party agrees to be sent documents in relation to that Part 11 application, but is always without prejudice to the fact that if that application succeeds and it's found that it was not proper service or the court doesn't have jurisdiction, you can't then rely on the fact that there's been that limited accommodation in terms of essentially proceeding on the basis as though or the documents can effectively be sent to the solicitors, as thereafter holding that party or making that party amenable to the jurisdiction or amenable to be served at that address in future.
Only, not generally, true, not generally. But for the purposes of an appeal, I mean, we do Part 11 cases day in, day out in the commercial court. And this is a novel proposition that if a party contests the jurisdiction of the court and says, I don't fall within one of the jurisdictional gateways, and then there's an argument about it, and they put in an address for service, and the other side serve witness statements on them and so forth, and then the party's successful and the other party appeals, that's not all part and parcel of the process for which the documents are deemed to be serviceable, if I can use that word, on the solicitor.
Well, I've made my submissions.
Yes, we have. I know.
Lordships, and
we have your submissions.
I feel which way the wind is
We're
blowing.
perhaps taking more time on this than it deserves in the context of the other important issues.
Yes, my lord. Now, in relation to the documents that have come up, I mean, the point I raised yesterday was that my learned friend was essentially seeking to rely on facts, or to put facts before your lordships which weren't in evidence and which weren't raised or weren't in evidence before the judge.
Yes.
And overnight, we received an indication from the other side they weren't going to seek to show your lordships any documents that were that either are in evidence before your lordships or that were in evidence before the judge, other than the notice of change which you've been taken to.
Yes.
Now, in those circumstances, my lord, I would submit that the proper course is that the other side is not permitted to rely on those sort of points of evidence that have been made at the bar. Now, if there is going to be any scope for them to rely on them, then we should be permitted the opportunity to put in such documents as we have obtained overnight, which at least show that that some of the crucial points of fact my learned friend sought to make are not correct. And what we have, my lord, so your lordship knows, is a judgment of His Honour Judge Waxman, as he then was, which I don't think would be controversial to put before your lordship's judgment of the commercial court, and 3 pages which relate to an earlier notice of change in relation to which my learned friend made various submissions as to what the effects of that earlier notice of change and the earlier position had been.
Right, let us just. Well, Mr. Hampton, we think the position is this, that the submission that was made, which is based on evidence that we do have, is that there was the 2017 document which is relied on, which refers to coming onto the record in place of the previous solicitors. The submission was that the previous solicitors had acted for Mr. Vick in relation to the Part 71 proceedings. So far, so good, if good. The further point that was made, which is unevidenced, as it seems to us, is that those previous solicitors had been on the record in relation to Part 71.2 in the sense of having done or said anything which showed that they were authorised to accept service of documents in relation to that application.
Yes.
Now, that is the evidential position as we understand it, and there's been no attempt to put forward any further documents, and that is the evidential position on which we would intend to proceed in the absence of an application to adduce further evidence.
Very good, my lord. In which case, I think that the document that I would propose to hand up to your lordships would just be the judgment of His Honour Judge Waxman.
And that's necessary because?
Well, that relates to a submission that was made by my learned friend in relation to the effect of the words for costs purposes only on the notice of change, which is in evidence before your lordships.
Right. Let's hear from Mr. Lodden.
Well, can I just check one point? I don't know if your ladyship received a letter from Freshfields this morning.
We did.
I haven't seen that, I'm afraid. No, I haven't seen it.
Can I, if your lordship doesn't have a copy, can I have that?
Yes, please.
Which is why additional copy as well, my lord, in case it's helpful. The purpose of that letter was to bring together the evidence that is already before this court in the bundles. So, if your lordship turns to, for example, paragraph 8, there's already evidence in the bundles dealing with CYK, and then Taylor Vintners taking over, and then being replaced by Brecker. Perhaps of particular value, paragraph 9, which deals with CYK's representation of Mr. Vick in connection with the Part 71 proceedings. And there's already a lot of evidence about this in the bundles before you. It's obviously on the record, for example, that they were instructed by Mr. Vick in connection with the set-aside application before Mr. Justice Cook and the subsequent variation of the date for the Part 71 hearing.
Yes.
There is evidence in Mr. Justice Henshaw's judgment, that's paragraph 9b, CYK accepted documents of Part 71 proceedings. 9c records that set out in Mr. Robinson's 10th witness statement, which is before you, the CYK sent a large number of letters in respect to the Part 71 proceedings, that they attended the Part 71 examination, and that Taylor Vintners represented Mr. Vick in relation to the subsequent applications, which were dealt with by Mr. Justice Tier in relation to service of the committal proceedings, in which, of course, a key argument was that the committal proceedings were incidental to the Part 71 order. Without wishing to take up too much time, I would invite your lordships to, if you have a moment, to look at the underlying sources referred to there, which we do submit, provide a strong evidential basis for the submission that CYK clearly acting for Mr. Vick in relation to Part 71 received and sent documents in connection with that.
Yeah, that was what I understood Ms. Delaney's submission to be, that they had in fact done so.
Exactly.
And my inquiry as to whether they had undertaken to do so was a separate inquiry, and as I understand it, there's no further documentation
Can't take
that's
it further than what's in the letter.
than what's in the letter. Yes, all right. Yeah, Mr. Hamilton, you want to show us the judgment of Mr. Justice Waxman? do you?
I will do in due course, my lord, if, when we get to that point.
Just when we get to it, is that objected to, Mr. Lodder, the Waxman judgment?
MacDonald, no. No.
No, so I'm sorry. Do forgive me, Mr. MacDonald. No, all right. Right, Mr. Hamilton, let's get to the submissions.
Yes, my lord.
Sorry.
My lord, on the question of service, the bank's case at first instance was that Mr. Vick had given breacher's address as the address for service for the purposes of Part 6.23, CPR 6.23, in relation to what the bank termed the Part 71 proceedings. And the bank was therefore entitled to service application on Mr. Vick at breacher's address. And the evidence relied upon in support of that assertion before the judge was the notice of change that you were shown. And also there is a footnote in the first instance skeleton, which it may be helpful to go to, my lord. It's in the supplementary bundle, tab 12, page 102, bundle 101. And it is paragraph 82 at the bottom of the page. You see about 4 lines from the bottom of the reference to the notice of change. And then there's a footnote number 38, which refers to an order made by Mrs. Justice Cockerell, 2nd of February 2021, in relation to the committal application.
I'm so sorry, I've lost you. I've got the
Page 101 of the supplemental.
101, thank you. Yeah,
And it's footnote 38,
yes, thank you.
bottom of the page. And so in addition to the notice of change, there's also reference to an order made by Mrs. Justice Cockerell on 2nd February 2021. And one sees that order included permission for Deutsche Bank to serve the amended committal application and further evidence on Mr. Vick by email to his solicitors. So, if anything, that rather tends to suggest that it was necessary for them to obtain that permission and that they weren't entitled to do so if Mr. Vick hadn't given Breach's address, an address for service.
In relation to the committal application.
Yes, my lord. That was the way that the case was put below, and Mr. Justice Cockerell effectively accepted the submissions made for Mr. Vick on the question of whether he'd given Breach's address for service, and that is paragraph 145 onwards in the judgment. That's core bundle tab 10, page 136. And she sets out there essentially the case advance for Mr. Vick at page paragraphs 145 and 146. And her conclusions, key conclusion, paragraph 149 sub 2, where she finds that it didn't appear for Mr. Vick in the disputes surrounding the Part 71 application. Paragraph 150 finds that the committal proceedings, so to the extent my learned friends seek to rely on those as somehow bleeding into the Part 71 or being an aspect of the Part 71 order, an application, those have run their course. And she goes on at subparagraphs 1 and 2 to find that Part 71 application itself doesn't have the effect of commencing proceedings. It doesn't give rise to, it's not an originating process. There are no Part 71 proceedings. It's a freestanding application. And linked to that, but I think in any event, a director or an officer of a debtor company who's summoned is in the position of a witness and isn't required to give an address for service under CPR 6.23. So she rejected implicitly the argument that Mr. Vick had given Breach's address, an address for service in relation to the Part 71 order, or that it could be said that he had given an address for service at one of his prior solicitors, which is somehow carried over to Breacher, and the Breacher had undertaken, stepped into the shoes of a solicitor who had previously been nominated for service of documents in relation to the Part 71 order.
Can I just ask you this, please? If a Part 71 director is akin to a witness and needn't give an address for service or have solicitors on the record, how does a party who wants to make an application under Part 71 serve them?
We'll have to serve them personally, or obtain an order for alternative service. Mr. Vick was served personally. So part 71 doesn't envisage, and I'll come on to that, my lady, but it doesn't envisage there'll be any need to get solicitors on the record. It doesn't in terms.
Would that stop the person concerned from saying, well, I'll voluntarily ask solicitors to accept service on my behalf?
Well, it would beg the question, my lady, service of what in relation to the part 71 order?
Well, the thing that is served on him personally in order to start the process.
Well, my lady, I mean, it certainly would be open to the court to make an order permitting alternative service. Whether parties could, by agreement, allow for the service by alternative means, I suppose there'd be nothing to stop that. Although, as a matter of fact, in this case, that isn't what happened.
No.
I mean, whether someone is required to give an address within the jurisdiction for service under 6.23 is a separate question as to whether they're entitled to give authority to solicitors to accept service of documents and to tell the other side that they can do so. But I think what you're saying is that Part 71 and a witness summons have to be personally served originally, and if there are any other documents in relation to the implementation of that summons or order which require under the rules to be served, then the default position is that they have to be served personally. There isn't a requirement to give an address within the jurisdiction for service, although if the witness or the respondent to the Part 71 order chooses to instruct solicitors, he may, but doesn't have to, authorise the solicitors to accept service of all documents on his behalf. Is that the position?
Yes, my lord. Obviously, a party could give an address for service in relation to Part 71 if they chose to do so. What that would quite mean in circumstances, or if it's right, that Part 71 doesn't in fact give rise to proceedings, maybe a different question. But in theory,
as you saw, when we were debating this with Mr. Laney, I was having trouble seeing why it mattered. And if it does require it to be done, but it hadn't in fact been done, then that isn't going to help us with whether breacher were by the 2017 document authorised to accept service, and if it did need to be done, then and was done by the 2017 document, that's the answer. But if it wasn't done by the 2017 document, it wasn't done by the 2017 document. So that's.
I mean, my lord, that might short circuit the entire question. I mean, I've addressed the way that the bank have put their argument, but I took your point yesterday, my lord, that it may just be a question of fact as to whether an address for service was given, whether it was necessary to give one or whether it was required to give one. The ultimate question is, was it given? And the judge obviously found that it wasn't given. So implicitly, she didn't accept that breacher had given its address for service. And she didn't accept that the evidence before her established that, in particular the notice of change of representative. I mean, if I take things out of order, my lord, we might cover that point now out of order. And in that case, I mean, the question is whether the judge was obviously wrong to have made a finding of fact that the breacher hadn't, or Mr. Vick hadn't given breacher's address of service. And that was a finding that was perfectly entitled to make on the basis of the evidence before her and the notice of change. Now, my learned friend's central submission in relation to the of those issues that I would submit, it was legitimate for my learned friend going to make by reference to the evidence that's before the court. The key one was in relation to the effect of the notice of change. And my learned friend sort of say, well, it can't have been limited by the words for costs purposes only, which appear on that notice of change, because those words couldn't have had any meaning in February 2017 when that notice was given. And I will now hand up, if I may, the judgment of Mr. Justice Waxman, because we say that's just not right, that there were no further costs proceedings on foot in 2017. I can hand up. My Lord, this is a judgment I don't propose to rely on the substance of it at all. It's the fact of the judgment. But you'll see, my Lord, it's dated the 28th of April
2016.
2016. But yeah, in fact, that is
2017.
almost getting a heart attack, my Lord. The hearing date is the 10th of April 2017.
This is wrong. Do we know which?
Well, the citation number is 2017 citation
Yes.
number. I'm told it's certainly 2017, which I'm grateful. And you'll see, my Lord, that paragraph 1, and indeed, yes, it's clear from the document itself. Paragraph 1, there's an application made by Mr. Vick to set aside an order made against him on paper by Sir Jeremy Cook on the 10th of October 2016. And if we go down to paragraph 15, 5, one can see what the order was. And let's see, on the claimant, Deutsche Bank, having applied on the 5th of December 2013 for non-party costs order, and skipping down, he makes an order in relation to those costs. Mr. Vick to pay Deutsche Bank's costs would against the First Defendant. The order of Mr. Justice Cook dated 8th of November 2013. Mr. Vick should be made party to any detailed assessment of the costs. Mr. Vick, paragraph 4, Mr. Vick is to pay Deutsche Bank's costs of the detailed assessment. So this is, my Lord, part of the non-party cost proceedings that Mr. Vick was subject to. So those are continuing after, or at the time of, the notice of change that was served in February 2017. And indeed, the costs proceedings, so that there's reference there to the detailed assessment that is being, that Mr. Justice Cook is ordering that Mr. Vick should be made party to, paragraph 2 of that order. And those detailed assessment proceedings continued until 2023, I believe. And then, my Lord, I think I'm right in saying that the final part of those costs proceedings were heard before your Lordship in, I think, March 2024, which was an appeal in relation to interest, in relation to those costs. I don't know whether your Lordship remembers that. It was a question as to whether there was a parties restricted to recovering interest for, I think, 6 years on any outstanding amounts. And your Lordship determined that appeal. So the costs proceedings were ongoing well after that. So in that context, to say that those words in the notice of change had no meaning is just not right, and it doesn't mean that therefore one can construe that notice of change as meaning the breacher came on the record for all purposes, including in relation to the Part 71 application, in circumstances where that examination had been held more than 10 years prior to that. And there's no indication that anybody at that time thought there was any life to it. Obviously, the committal proceedings were ongoing, but as Mrs. Justice Cockerell found, the committal proceedings themselves had also come to an end before this application was served, or purported to be served, on Mr. Vick by a breacher. So,
if we just look at the document, it's at tab 6 of the supplementary bundle. The words "for cost purposes only" appear in the title of the action.
yes, my lord.
That's because that's what you do if you seek a non-party costs order under section 51. The rules provide that you add the non-party as a party for cost purposes only.
Yes, my lord.
But the actual box that breachers have ticked, it simply says that breachers have been instructed to act on behalf of a second defendant claim in place of Taylor Vintners. So that means Mr. Vick. And doesn't the word "in this claim" cover all aspects of the claim, which is the claim number at the top?
Well, my lord, that begs the question as to if Mr. Vick was joined for the purposes of costs only, he was not party himself to
He
the
wasn't
substantive
party to the
proceedings.
substantive action. I understand that.
He's not himself party to therefore to the judgment that was given, which creates the judgment debt. So the cost proceedings are essentially a separate claim, and although it doesn't make things easy that all of these claims have been given or essentially treated as having the same claim number, but an application for a non-party costs order gives rise to separate proceedings, because prior to that, Mr. Vick wasn't party to the main proceedings. He's not made party to the main proceedings by being joined for cost purposes only. He's party to the non-party costs proceedings.
Why are they
Well, he's
separate proceedings?
He's joined to the claim.
Yeah.
He's joined to the claim for cost purposes only. But there's only one claim number. And I understand entirely that Mr. Vick is, because he's only been joined for cost purposes only, does not become a party to the main proceedings. He's not party to the judgment. But he is joined to the claim, and in the claim, breachers are acting for him. And the Part 71 is also part of that claim. It's got the same claim number, and the purpose of exercising the Part 71 powers is so that he can give information to enable the judgment which has been obtained in the claim to be enforced. That's the purpose of it.
Well,
I'm just wondering, just construing this document, why does it not say breachers are acting for Mr. Vick in relation to claim number CL 2009-00709?
well, my lord, the second defendant is defined in the box at the top as being Mr. Vick for cost purposes only.
Well, so he is in the 71.2 order.
Yes, well,
He is given the title in that order of defendant for cost purposes only.
well, my lord, in
At
relation,
page 136.
He's the same person. Mr. Vick is Mr. Vick, however you describe him. It's like saying the evening star is the same as the morning star. They're both different ways of referring to the same planet.
well,
And in the same way, calling Mr. Vick second defendant to the claim for cost purposes or respondent to Part 71 are just different ways of referring to Mr. Vick.
my lord, there may be different ways of referring to Mr. Vick, but the question is, in what capacity or in what actions So Mr. Vick may be party to multiple proceedings.
Well, you can obviously
may
be
be-
party to two different claims. I understand that, but I'm struggling a little bit with the idea. You can say, these solicitors are acting for me in this claim, but by that I only mean little bits of it. I mean an application for discovery, or an application for costs, or an application for the other. And what you've said is they're acting for me in this claim. That's what I'm having difficulty with.
Well, look, I mean, the example you give, you say acting for me in relation to discovery or some application. I mean, that an application for discovery is not within proceedings, is not an originating proceeding of the kind we've been discussing. And that's just an interlocutory application, which depends or is part of the main proceedings. But
Are you saying that Part 71 proceedings are somehow divorced from the main proceedings and should have been given a completely different claim number?
no, my lord, my lady, the Part 71 order is part of the main proceedings because that is to assist with the enforcement of the judgment.
Right.
But the question then is Mr. Vick party to the main proceedings, or is he party to the cost proceedings that come out of it by virtue of the non-party costs order? The non-party costs order commences proceedings against Mr. Vick. That is an independent claim to make Mr. Vick liable for SHI's judgment debt. I beg your pardon, for the costs order against SHI.
I think your case would be much stronger if breaches had said in terms, we've been instructed to act for Mr. Vick in relation to costs only. Now, if they'd said that, then there'd be a question of whether you could limit your representation in that way. But they don't. That's why I say I think it's a question of construction of the form. They don't say that. You say that's the effect of what they have said.
Yes, my lord. I mean, it's a standard form. Now, looking, why not see where one would add
After the words Taylor Vintners Limited, LLP, we're instructed to act on behalf of the second defendant in this claim in place for the purposes of costs only.
my lady, whether that appears in box B below as the qualification, rather than in the heading, where, I mean, the heading, that box says name of defendant, Mr. Vick, for cost purposes only, and then the references below to the second defendant are obviously a reference back to the second defendant as defined above.
At the date that this was sent, what was the status of the committal proceedings?
The committal proceedings had not yet been commenced, but various applications were being made in relation to them, in relation to, I believe, the question of whether proceedings could be taken under the court's inherent jurisdiction and under the procedure under CPR 81, as opposed to Deutsche Bank being required just to use the procedure under CPR 71.8. And I'm not sure whether by this stage applications were also being made in relation to whether Deutsche Bank could have permission to serve Mr. Vick out of the jurisdiction, or whether it needed permission to serve Mr. Vick.
Did the breaches did act for Mr. Vick in the committal proceedings?
Oh my lord, they were instructed by him in relation to committal proceedings, and they did work in relation to committal proceedings, but my understanding, and I don't think there's any evidence on this in the bundle, and it was not a point that was taken below, or that Mr. Justice Cockerell was shown evidence on, to the best of my recollection. But they never it was never accepted that service could be effected on Mr. Vick in relation to committal proceedings via breacher, and I've shown you, my lord, the footnote in Deutsche Bank's first instance skeleton, where Mr. Justice Cockerell made an order for alternative service on breach, which wouldn't have been necessary if Mr. Vick had given their address for service. If he'd
Might have been,
volunteered.
because Part 81, you prima facie have to serve personally, don't you?
But yes, my lord, but in relation to the committal application itself, but at that stage, the committal application had been served by alternative means on Mr. Vick, and it was an amended copy of the committal application. Now, it might be said that the amended committal application would also have had to have been served personally, or that was a possibility. But the other documents as well were the subject of Mr. Justice Cockerell's order. And indeed, I mean, as we discussed, I think, in relation to Part 71, it must be right that a party, even if what is ordinarily necessary under the rules is that there be personal service, one can still agree as a party to waive the required personal service and to give an address at which one may be served in any event.
So does it all boil down to how we understand or construe this notice of change?
Well, my lady, it's not
you
how...
submit that you submit that because of the way that Mr. Vick is defined, it's obvious that the solicitors are only on the record as dealing with costs.
Well, that's part of it, my lady. Well, the two answers to that question. Firstly, it's not with respect just how you construe it. The question is whether the judge was obviously wrong to have construed it as not.
Is that right? Aren't questions of construction questions of law?
Well, there's a question of construction or a question of fact, my lord.
Well, if the resolution of the factual issue depends on a matter of construction, and the construction is wrong, then that must infect the factual conclusion.
Well, it might be a case, my lady, where you say that you're in no worse position than the first instance judge to decide the point. But that's...
Anyway, you say the judge was entirely right. She was entitled to reach the conclusion that she did on the evidence before her.
Yes, my lord. And the point that my learned friend has made, I mean, that wasn't a dress rehearsal.
No.
There is meant to be finality. So the fact that you may form a different view, your lordships may form a different view, unless it's clear the judge was wrong, shouldn't mean that you then set aside what she said, because that completely undermines the finality of the first instance application, the first instance judgment. That's part of the answer. The other part of the answer is the status of Taylor Vintners and what their role was, what they were on the record for. And that is where there isn't really any evidence. And prior to that, the extent to which CYK were on the record, or not on the record, and more than that, and my Lord Justice Popplewell made the point that what does on the record mean? Is that necessarily the same as having given address for service? And there just isn't before your lordships, and wasn't before Mrs. Justice Cockerell, any clear evidence to, or any meaningful evidence to establish what the position was. So when my learned friend submitted yesterday that the position was, it was clear that Cook, Young and Keaton had given, Mr. Vick had given Cook, Young and Keaton's address for service in relation to the Part 71 application, and that Taylor Vintners had stepped into the shoes of Cook, Young and Keaton in relation to the Part 71 application, are both propositions which there isn't evidence of before your lordships, and which are contested, and the documents which I would otherwise have shown you in my submission make that quite clear. So it's not an assumption that your lordships can make, or that the judge could have made. So even if your lordships find that the inclusion of the words "for cost purposes only" by themselves don't get Mr. Vick home on this point, because he should be construed as taking over from Taylor Vintners in all respects, there isn't any way of answering the question what Taylor Vintners' role was, and what claim or claims Taylor Vintners was on the record in relation to. My Lord, I think made a my Lord Justice Nugee made a point in relation to the form of the Part 71 order, and that is in the supplemental bundle, tab 16, page 136. And it was said that, and my Lord made the point that the heading of that, the same claim number and names Mr. Vick, for cost purposes only. But the point there is that's a standard form document. One puts in that box the heading of the proceedings in which the Part 71 order is made. So ordinarily, in the ordinary case, if Mr. Vick hadn't been joined as a party for cost purposes, not in the non-party costs order, his name would not have appeared there. So notwithstanding that he would have been the subject of the Part 71 order, his name would not have appeared in the heading. It would have appeared, I think, for the first time, about a third of the way down. Wording appears in number 1, and the court orders that Mr. Alexander Vick, who is an officer of the Judgment Debtor Company. So, my Lord, one can't, in my submission, take anything from the fact that the heading of the standard form, or the Part 71 order in its standard form, makes reference to Mr. Vick and to his being party to the proceedings for cost purposes only, as being in any way indicative that the identity between that and the wording in the notice of change shows that these are one and the same proceeding, and that that notice of change this application as well. Yes. If I turn to the way, well, just think about time, my lords, because I see that the time is 3:45, and I have been taken off my course somewhat, and Mr. Laney will obviously want an opportunity to reply. So I will cut my cloth. If one looks in relation to the question of whether these are, whether there is such a thing as Part 71 proceedings, whether they give rise to a separate claim in their own right, so as to engage CPR Part CPR 6.23. Your Lordships have shown the case of GFN and Bank Credit Claimant. I don't think we need to go there again, my Lord, and I don't think there's an issue between the parties in relation to what one gets from that. You'll recall, my Lords, that Lord Scott drew a distinction between an interlocutory application designed to regulate or assist in some way the conduct of the substantive action, which he said would not constitute proceedings, and he contrasted that with an application which raised issues as to the rights of the parties, which were in substance independent of the issues in dispute in the parent action. And those would normally constitute proceedings for those purposes. And the difference between my learned friend and I is in how those apply in the context of the Part 71 application. And the point is that Part 71 is essentially an aid to enforcement. It doesn't determine any issue. It's not intended to raise any issue between the officer of the judgment debtor and the claimant, the judgment creditor. There's no issue as to whether the judgment debt is due. It's simply an exercise in obtaining information. So it doesn't in any way determine any substantive rights between the parties. And my Lord Justice Popplewell had that point, I think. My learned friend didn't, my submission, have any real answer to that. In relation to the case of Tonstate Group and Wojciechowski, first point to make about that, if one looks at the cover page of that case, in the authorities bundle, which is tab 24, page 602. The point there is simply that the respondent in that case didn't appear and wasn't represented. So an ordinary principle is in accordance with the practice direction or citation of authority. That can't be taken as good authority for any proposition of law or as extending the law in any respect. But in terms of the question that arose and whether the significance of the fact that in that case banker's trust order was being treated as giving rise to proceedings, well, it is not clear from the judgment what the answer to that is, and as the point was made that it wasn't considered in the judgment. But the ordinary practice in relation to Norwich Pharmacal orders, my lord, is that they are made these days by way of a Part 8 application notice. And my submission, the same is true in relation to bankers' trust orders. And if a claim is made or an application is made by way of a claim form, then that certainly is proceedings. And service with the claim form will engage the obligation to give an address for service in the jurisdiction. It will, in the ordinary course, require the parties to file and serve pleadings in due course. And the claim does give rise to proceedings. So my submission, that is the answer to that case. If one looks then at Part 71 itself and the details of Part 71, and your lordships don't have the benefit of the White Book, I do have copies of the relevant parts of the White Book if it would be helpful to hand those up.
Which parts of this do you want us to look at?
So my lord, running through quickly, it's an application that's typically made without notice. One gets that from 71.22. 71.23, it's in standard form, it contains standard information. 71.24, it can be dealt with by a court officer rather than a judge. 71.25, if basic requirements are met, then it will be granted, the presumption it will be granted, and we referred to a judge only if there's a question mark as to whether those basic requirements have been met. It is intended to be a simple and essentially administrative process. Then if one looks at how it describes the person who's made subject to the order, consistently, starting at paragraph 71.26, refers to a person served with an order issued under this rule. And that form of wording tracks throughout the Part 71. So 71.31, first person ordered to attend court. and that appears in various other provisions, going through to paragraph CPR 71.7 and paragraph 71.8.
Is there any provision for how the application notice is to be?
Well, my lady, that was going to be my next point, which is that there is no requirement to serve the application notice.
They're usually done as part of it, aren't they?
Yes, one of it.
yes.
Done ex parte, and so in CPR 23 has specific requirements that the application itself must be served. It's 23.7 and 23.9, whether it's made ex parte, in which case obviously served once the order is made, or obviously on notice it must be served as soon as practical. You don't have that provision in Part 71. So my understanding is normally the application notice is not served, and certainly there's no requirement that it be served. And the party served, the debtor or the officer of the debtor served, is required to attend simply by virtue of having been served with the order. So in those circumstances, to say that an application under Part 71 can give rise to proceedings, can be treated as a claim form, just doesn't follow from the form of the order. And sorry, returning to the point I was making about the reference to the person served with the order as being a person who is required to attend, a person who is served with the order, it is carefully avoiding any wording that suggests that they're thereby made a respondent to an application or a defendant to proceedings. They are in the same position as said in Matter number 4, essentially of a witness. They're not in any way being made party to either the main proceedings in relation to which the application is made, or to any separate proceedings constituted by the Part 71 application or commenced by the Part 71 application itself. So that answers the suggestion that this is a claim or this gives rise to proceedings and therefore engages the requirement to give an address for service. Even if it could be said to be a claim, I mean, there is nothing in Part 71 itself or in the standard form order. If I can take your lordships back to the order that was made by Mr. Justice Tier in the supplemental bundle, tab 16. Page 136. There's no indication in there, and in particular, if one turns on to page 138, is essentially the information that's provided to parties served with that order as part of the form. There's nothing in there to suggest that they are required to respond in any way or to give any address for service. And one would expect that would be the case if a party served with an application, or served rather with an order in that respect, was to be treated as a party. So in those circumstances, my lord, on any view, they can't be within the scope of CPR 6.23. Party is required to give an address for service in the proceedings. Coming back then briefly, and I will conclude on this point, my lord. In relation to the question then of whether there is a single claim and that everything within or everything with the case number printed on it, the 2009 709 case number is all part of a single proceeding. My submission that simply can't be right. One can't rely just on the fact that they have the same claim number. And that is illustrated by the fact of the committal proceedings, which it is accepted, and I think it appears in the judgment of Mr. Justice Tier, that the committal proceedings or a committal application is in its own right a claim form. It does give rise to its own proceedings. And those are proceedings between Deutsche Bank and Mr. Vick. And SHI itself cannot be described as being party to those committal proceedings in any meaningful sense. And I believe they've been provided with the documents, but have not participated in any way or been required to participate in any way in relation to the committal proceedings. In my submission, that makes clear that there are separate elements to the proceedings, and it's not just determined by the claim number. And the same goes for the cost proceedings, the third-party cost proceedings, which again don't involve SHI.
They are part of the main proceedings, aren't
They
they?
are part
That's
of the
why
main
that's why
proceedings,
Mr. Vick has been joined as a defendant
Yes,
to those proceedings for
but-
cost
but-
purposes.
But that's essentially a standard form wording that then is used
Well,
consistently.
it's not only standard form wording; it is as a matter of substance.
Yes, my lord. And that's my point. Is that
It is
as
a
matter of
process
substance,
in those main proceedings.
you have different claims, different proceedings, which have been given the same or assigned the same claim number, treated as having the same claim number. But that is a matter of form. As a matter of substance, there are separate claims, there are separate proceedings, and the Part 71 application is an application in the main proceedings to which Mr. Vick is not a party, and it is an aspect of those proceedings. It is not Part 71 application is not a claim in its own right.
It is an application in the main proceedings.
Yes, my lord, unless I can assist your lordship's further, that concludes what I thank you very much, my lord.
Thank you very much. Yes, Mr. Lane.
My lord, I have 4 topics on which I'd like to briefly reply. The first is the nature of the obligation under Part 71. The second relates to the relief the bank is seeking. The third relates to points raised on case management powers. And the fourth will be very brief on service. So just starting with the nature of the obligation under Part 71, my Lord Justice Nugee asked my learned friend at today's transcript, page 12, about what the obligations were under the CPR 71 order and whether there might be different analyses depending on the obligations. In response, my learned friend sought to characterise the obligation of Mr. Vick as requiring him to attend on a particular day to answer the questions asked of him, such that his obligation, he said, was completed on that day and that the Part 71 order was therefore at an end. And that's at page 19 to 20 of Day 2 transcript. Now, on the face of the Part 71 order, it's clear that Mr. Vick's obligation was not what was presented. It was rather, and this is at the supplemental bundle, tab 16, that the obligation was to provide all information, and we can see that from the face of it on paragraph, just under paragraph 1. So he is to attend court for the purpose of to provide information about the judgment debtor's means and any other information needed to enforce the judgment or order. Paragraph 2, all documents in the judgment debtor's control. And then over the page to 138, the information required on the right-hand side is said to be full details. And if you're being asked to attend as an officer of a company, the same details about the company and all documents. Now, that implies with it, as Mrs. Justice Mulder found, and I'll show you this, that you are obliged not only to come to court, but you're obliged, the obligation is to provide the information and documents, and you are obliged to answer the questions fully and truthfully, and to provide the documents in complete form. So that's the first point. There's a quality to the way in which you have to answer them. And the second is the obligation is to provide the information and the documents, which are the means of doing so are given as the court attendance, but it's not, one can't say that the court attendance is the long and short of the obligation. And Mrs. Justice Mulder found in the next tab, at tab 17, that was the basis on which Mr. Vick was convicted for committal, because you can see on page 143, it was the failure to provide truthful and or complete information or the documents. Now, the other point I should draw to the court's attention is that Mr. Vick previously argued that his obligation was only to attend and answer the questions asked of him. And in fact, he went so far as to say that the order was not only complete, but did not require him to answer truthfully. And that argument was rejected by Mrs. Justice Cockrell in an earlier decision in these proceedings in 2020. And I'm just going to hand it up to you so that you have it, if I may. It's only arisen in response to what was said in my learned friend's questions and answers today. And you can note in the relevant paragraphs are 28 to 30, 34, 35, and 223 to 245. And you see her findings as to, for example, it's common ground, there was no disclosure of any electronic documents when that argument was advanced. And in the final section to which I've referred you to, 223 onwards, Mrs. Justice Cockrell described the breach as functional and going to public interest, which reflected the fact that the obligation is to provide information. And it follows that if Mr. Vick has not answered the questions truthfully or fully, he's not provided the information, and the information remains outstanding, and hence he has not complied. Those were her findings.
Sorry, where do we find that?
So it starts at 223, my lady, on page 41. And the functional point that I mentioned was at 242. And you may also wish to look at 238 and 239. While you're in the judgment, my lord, you can see that in this judgment, Mrs. Justice Cockrell also addressed the release point, which my learned friend focused on today at page 50 to 51 of day 2 of the transcript. And I've obviously already shown you that Lord Justice Gross had held that Mr. Vick's release had no effect on the court's power to entertain the committal application. That, of course, being an incident of the Part 71 order they were then considering. That was at paragraph 58, supplementary bundle, tab 28, page 220. Mrs. Justice Cockrell made the same finding in her judgment in front of you. She dealt with the release of Mr. Vick at paragraphs 37 to 38 of this judgment and came back to it at paragraph 241.
241, did you say?
That's right. So the fact that Mr. Vick was released from his oath didn't mean he was released from the obligation to comply. If so, there would have been no basis to make a committal order which was in significant part aimed at compliance. And the cases in the bundle establish that the fact that a contemnor is punished does not mean he's not obliged to remedy a continuing failure with his obligations. There was no kind of election in any formal sense at the hearing before Mr. Justice Cook, as my learned friend appeared to suggest today, page 37 and page 44 of day 2 transcript. You saw the extract. Mr. Justice Cook was concerned to ensure that Mr. Vick was given full notice of the respects in which it was said he had not complied, and ordered that there could not therefore be a summary process under 71.8, which is what the bank was aiming at, but rather the committal had to be brought under Part 81. Ironically, Mr. Vick then issued proceedings saying the bank had taken the wrong course. Mrs. Justice Cockrell held that the bank was interested in a further examination to obtain the information in paragraph 28 of her judgment. So there was no election to pursue committal and give up forevermore the right to seek compliance with Mr. Vick's continuing obligation, nor did the end of the examination on the 11th of December 2015 by itself mean that the obligation was spent. If so, then there would have been no point making an order for committal seeking compliance. A further flaw in my learned friend's argument was to contend that the examination could have been adjourned, but because it wasn't, the bank cannot now ask for the examination to be resumed. But the bank is not seeking a resumption of the same examination. The bank is seeking a further examination. And the point can be demonstrated if it was discovered a couple of days after the hearing that Mr. Vick had withheld huge caches of documents or hadn't provided information. It couldn't be said that by not adjourning, the bank had waived the right to seek a further examination and only had the right to seek committal.
Well, the argument that's being put is that you'd have to do it by way of a separate order.
But that assumes by the virtue of adjournment that the obligation has been spent and or that the only remedy is committal.
Yeah.
And that's the flaw in the argument. And there is nothing remotely abusive, which was also suggested, about pursuing multiple options. The court is helping aid enforcement in whichever way it sees fit. May I remind you of the Ablyazov case? Given the time, I won't go to it, but I showed it to you, and it's worth making the point that just on the facts, if your lordships wish to have it in front of you, it's in tab 13, the bundle, and the relevant page is 365, paragraph 175. The bank in that case obtained a worldwide freezing order against Mr. Ablyazov, which included the ancillary asset disclosure provisions. You see that at paragraph 10. Mr. Ablyazov was ordered to be cross-examined on oath on his asset disclosure affidavit because he'd failed to give adequate disclosure. Following the cross-examination, he was committed for his lies in relation to the cross-examination on assets, found guilty of contempt and sentenced to 22 months imprisonment. That's at paragraph 17. After he was found guilty of contempt, he sought to evade the sentence, and the court didn't hesitate in making further orders to secure compliance with its prior order. So the bank applied for 3 orders. One was a mandatory injunction requiring him to deliver himself up to the tipstaff. The second was an order requiring him to give full and proper disclosure of his assets and dealings with them since the worldwide freezing order. And thirdly, an unless order such that if he didn't deliver himself up or provide the disclosure, he would be debarred from defending the claims against him. And orders to that effect were granted by Mr. Justice Tier. And the order that Mr. Ablyazov give proper disclosure of his assets a second time is made after he had been held in contempt for failing to do so the first time. He appealed to the Court of Appeal, and the relevant appeal point for your Lordship's purposes is at 118 of the judgment, page 347 of the bundle. That was in Lord Justice Ricks's reasoning, applying Beckel and McLean, and saying that it was important for all three orders to be made. And the words I showed you yesterday at 187, paragraph 187, that was that Mr. Ablyazov was only being asked essentially to do what he had always been ordered to do. So I just ask you to have a look at that to the extent of showing that orders were not spent and the court wasn't functus, and the finding of contempt made no difference to the desirability of enforcing the original order for disclosure ancillary to the freezing injunction. May I then move on to the third topic, which is case management powers. At page 13 to 15 of Day 2 transcript, my learned friend argued that the power under CPR 3.12a to extend or shorten time for a deadline could not work as a basis for the bank's application because it would retrospectively invalidate the contempt. Now, this point we suggest is substance over form, because it proceeds on the assumption that what the court is doing when it exercises its power is to in some way reinvent the order made, so it's not to be treated as having always been in the revised form. Now, that's not how the order works. So if you take the case of Rowland, where Mr. Stafford had complied with all parts of the order except paragraph 3.2, and what the judge did was to vary the date for compliance with that part when discharging the contempt of Mr. Stanford. He did that by means of a new order, but he was clear that he was varying the date for compliance, and he likely was exercising a power in the inherent jurisdiction or a case management power, and that did not retrospectively invalidate Mr. Stanford's contempt for breach of the order. It was just a new order that he do the thing he had not done by a new date. And my Lord Justice Popplewell asked at Day 2 of the transcript, page 15, whether my learned friend's submission would work in the same way for other obligations under the order. And my answer is the one I've just given you, that it works in the same way for the other obligations. So as to the obligation to provide documents under the Part 71 order, Mr. Vick failed to do that by the deadline, and any new order would require him to do it by a new deadline, similarly to provide truthful answers. And the other point on this topic is whether these powers provide a basis to uphold the bank's appeal. Now, my lord, the bank's application notice, as you know, relies both on the court's inherent jurisdiction generally and on the jurisdiction inherent in CPR 71.2, either of which, it is said, would give the court the power to make its own order effective. It's the way we have put our application throughout. So we have already asked the court to make the application under the CPR's inherent jurisdiction generally, which, as I said to you yesterday, would include the case management powers. All 3.12 does is to codify aspects of the inherent jurisdiction. If the court felt that an express order under 3.12 had to be made and it was in some way distinct from the inherent jurisdiction, the court is entitled to do so of its own motion, and that is clear from CPR 3.3. And as I say, the arguments are exactly the same because the power is exactly the same, whether you source it in the inherent jurisdiction or in the codification of the same power in CPR 3.12. And can I pick up one point then now on ground 2? I'm sorry, I missed that out of my list of topics, so that's I think a 3A. My learned friend made a rather unattractive submission at this afternoon in the transcript that essentially Mr. Vick wouldn't give the relevant information, so this court should therefore take the view, as the judge did, that any order against him would
I
be
think, in
futile.
fairness to Mr. Blessweather, his submission was the judge was entitled to look at the whole history and say, I don't think he will. I don't think he ever went so far as to suggest that his client wouldn't comply.
In a sense, though, my lady, he has to, because if actually his case is that Mr. Vick would comply, then the judge plainly wasn't entitled to make the findings she did. So running through his submission has to be the answer that the judge was on a rational basis entitled to suggest that his client wouldn't comply, and he doesn't have instructions to say otherwise, putting it at its mildest. In which case, that's just the same form of blackmail that Mr. Justice Bryan rejected, and in a sense absolutely underlines why this court cannot uphold that order, because it's tantamount to saying if you have a really bad contemnor who consistently thumbs his nose at the court, this court will enable him to do so. Now, that is distinct from saying there have been so many attempts to get him to do something that it's futile, so taking the cases, the Wilkinson type of case I showed you. And rightly, it's not suggested that that line of authorities is the justification for this argument. The justification is the history says that Mr. Vick's really difficult and won't tell the truth. So with respect, that isn't a submission that we think the court should or could entertain. But in any case, the attempt to bolster this submission by saying, and the bank doesn't really want it anyway, and thinks it's pointless given what was said at the sentencing hearing, that submission is not correct, not least because things have moved on in the sense that, and this is what the evidence covers, that documents have been produced since the sentencing hearing on the 24th of March 2023, and these relate to, in part, Devon Park, one of the topics that is listed, and there are 5 boxes worth of new evidence from Mr. Olaf, although I'm not clear as to the date on that from the evidence, just to be clear, it's the 460 pages that I have the date for. But there clearly is information there, plus Mr. Vick's own submissions at the hearing in response to the bank's case that there was no point, was that no, he's already started the process of gathering the information. So in those circumstances, it's not the case that the bank is stuck with the concept that there is no point, because things have plainly moved on. And it's quite clear that cross-examination of Mr. Vick has produced valuable material. I mentioned yesterday the 60 million of Confirm It shares that have been realised. So we would suggest that the highly unattractive submission shouldn't be entertained, but it's not right anyway. The final topic was then service, and I can take this very briefly because there are 2 points that I think my Lord Justice Nugee made, which were, and my Lord Justice Popplewell. The first is that if in fact it's right that an address has been provided for service, then that probably means the first point as to whether these are or are not proceedings requiring an address falls away. And secondly, if breaches letter of representation is not limited in the way that has been argued, then they are acting for Mr. Vick on more than what has been said, including the Part 71. And on that second point, my learned friend relied on the decision of Mr. Justice Waxman, but it didn't help him because of the reasons my Lord Justice Nugee identified, which is that all that the notice of change was doing was identifying Mr. Vick and with his status as a defendant in the main action as a non-party cost defendant. But Breacher was not simply dealing with non-party costs because they were dealing with committal. So as a matter of fact, they have dealt with committal. And as a matter of fact, there are, they were found, and this is at page 146 of the core bundle, the judge recorded Mr. Vick's argument that Mr. Vick is a party to the cost proceedings and to the committal proceedings, and Breacher acts for him in relation to those proceedings. And the judge also referred to the fact that Mr. Vick was previously served with documents relating to the costs and committal proceedings. So she went on to say, doesn't mean Mr. Vick would be served with Part 71, but there's no doubt that they were acting for him and more than just the non-party cost proceedings. So their argument on limitation doesn't work. Now, having dealt with those 2 points, it's unnecessary to deal with the meaning of proceedings, but I do have an answer to the question I said I would come back on, my lord, and I can take it briefly and just identify what it is, and if you wish me to develop it, I can, which is that you asked me yesterday about the difference between a witness summons and a Part 71 order and how that worked in the definition of proceedings for the purposes of 6.23. And I gave you preliminary answers at pages 154 to 168 of day 1 of the transcript, and I reserve my position. So, and there are 2 points I wish to make. The first is I need to clarify 1 point. I said at page 162 of the transcript, lines 2 to 5, that Mr. Vick embodied SHI for the purposes of the order, and Lord Justice Nugee picked me up on that, and I accept that Lord Justice Nugee was right to do so. I should mention the reason I used that phraseology was because it's what Mr. Justice Cook found in his 2015 judgment, supplementary bundle, tab 25, page 193, as to the special status occupied by Mr. Vick in this case, which he said took it out of the norm, and that was at paragraph 30, but it didn't help me on the point on proceedings. The position on proceedings, as I said to you, is that essentially the rules envisage that where it is for case management purposes or otherwise necessary to have proceedings and an address for service, then there should be flexibility for the courts to be able to do so. And that's why it's a context-sensitive approach, as suggested in Gotti or the narrower test in GFN. And the position with a witness summons is simply that it's purely an administrative act. The court issues the summons and the witness attends the trial on liability in the usual way. They're not party to any proceedings, and CPR 6.23 wouldn't in those circumstances apply to them because there's no ray as between the summonser and the summons. The court just issues an order and the witness complies with it or not. Now, the position we suggest would change if the witness issues an application under CPR 34.3 subparagraph 4 to set aside or vary the summons. That may set in train proceedings in which there is an issue between the summonser and the summons, and that is clear from the White Book notes at 34.3.5. And the burden then is on the person summonsing the witness to justify it. That then would leave the court determining their respective rights and would satisfy the proceedings test in Gotti and also the test in GFN. And it connects with the point, as I say, that the proceedings isn't defined. It has to be looked at in context, and there is a broad definition. Looking at the application by contrast under Part 71, and this is the point I was making yesterday, once a Part 71 order is made, it commences a separate and independent method of enforcement after judgment. And the rules, for example, in 70.1 talk about the specific methods of enforcement that are contained in Part 71 to 73, 81, 83, 84 and 89. So the CPR identifies CPR 71 as a specific method of enforcement. It also identifies committal, and it's common ground that committal can give rise to separate proceedings. So we suggest that CPR 71 is a specific statutory method of enforcement created by the rules, and its process is only available against debtors and officers, and an officer is required to attend the examination in those enforcement proceedings between the judgment creditor and the judgment debtor. So it's not like a witness summons in that way, it's rather a new enforcement process. Masri, I accept, suggests the position of the officer is closer to the ordinary witness than officers of a company being compulsorily wound up. But the Lord Mance was there addressing the question of whether Part 71 was addressed at officers outside the jurisdiction, not the question of whether Part 71 addressed the position as to proceedings for the purposes of CPR 6.23. So, my lord, those were the submissions that I said I would come back to.
I'm still rather perplexed as to how this point A arises, and B, how the arguments that both sides have been addressing assist their own case. If there is an obligation, because they are proceedings, to give an address for service, that doesn't tell one whether the 2017 document has done that so far as breacher are concerned in relation to the current application. But if it were relevant, as it strikes me the only way it might be relevant is that if it is a process and doesn't constitute proceedings, then it might well be characterised as a process in the main proceedings. And processes don't happen in the ether. And that would rather suggest that when breachers say that they are giving their address for service in relation to the claim, that covers this process. So I'm slightly perplexed why you're arguing that they're proceedings, independent proceedings, and why Mr. Hamilton is arguing the contrary. But
I don't have to argue they're independent proceedings. What Mr. Hamilton is saying is that it's just a process that's not part of any proceedings. That's his argument. And that it's simply an administrative act. And so it's not part of any proceedings at all. And that's his first argument. I think his second argument is that insofar as breacher gave an address for service, which would suggest that these are part of the main proceedings, then it was limited to...
Yes, I understand that.
So that's what he's saying. We are saying that these are plainly proceedings and therefore could be part of the main proceedings or their own proceedings, but they're certainly something with which, in relation to which, with Mr. Vick can be served. And secondly, that even if we're wrong about that, Mr. Vick gave an address for service and was served sensibly, first on CYK and then continuing by breacher. So those are our points. But because we say the second point is crystal clear, for the reasons debated today in particular, we don't really need the first. But I think my point boils down to, in a sense, once Mr. Vick applied to set aside the CPR 71 order, it wasn't simply an administrative process that formed no part of any proceedings. It became proceedings, and that was what we were setting out in some ways in our letter, because you can see the amount of dealings that had to be had in relation to the Part 71 process, and therefore it doesn't fall within the description that Mr. Hamilton tried to give you.
Thank you.
My lord, those are my submissions unless I can help you further on any points.
Well, as you all have gathered, we're going to reserve judgment. Thank you very much to you all. My apologies again to Mr. MacDonald and Mr. Nodder. I'm very sorry. You'll know that you'll get notified when we propose to hand down judgment. It'll come out to you in draft, opportunity for corrections and typographical errors, corrections of an administrative nature, not an opportunity to re-argue points. It'll have the embargo on it, which you know, but we always emphasise is very important and must be very strictly observed. There are sanctions, potential sanctions, if that doesn't take place. In the usual way, we'll ask you at that stage to draw up an agreed order. If you can't agree, we'll have rival submissions in writing and deal with them on paper in the usual way. Thank you all very much.
Court rise in favour.